do appear for the first.
Today we are having a discipline. We have Judge Murima appear online. Can you? Good afternoon.
Yes, good afternoon.
Yes, comfortably.
My Lord, I do hold brief for Mr. Paul Jamodi, Mr. Eric Kumbo, Mr. Moses Kipoge, and Mr. Ken Murray. Holding for the first and third respondent. My Lord, I also hold brief for Mr. Dr. Mugambi, then Professor Kiburi Kindi, Executive President.
On behalf of Mr. Eric Ogolla and Professor Togo Senior Counsel, I also hold brief for Ms. Mercy Faki for the fifth and
My Lord, my lady, my name is Nura. I appear for the ninth respondent, that is the IEPC. I also hold brief for Mr. Maha Somani.
About 9 respondents.
Yes, yes, ninth respondent.
Mr. Tusa is the 8th respondent.
Is there a quorum?
It would seem so, because we didn't have a quorum sheet. Get listing of anyone else who may not have been
Please
present.
speak loudly. We have Judge Murima who must support what we are talking about.
I'm sorry, I figured that the microphone was capturing the Law Society of Kenya, the second interested party, and the Secretary to the Intergovernmental Relations Secretary. But in the intervening period, my client, who is present in court,
What is coming afterwards?
the motion by the petitioner applicant, dated the 28th of May, 2025.
Yes.
In the intervening period, the petitioner applicant has instructed me to file the motion instant it is on the CTS. We furnish Malawian friends with a copy of that motion via email. I also shared on WhatsApp Messenger with such of Malawian friends that were present here. The thrust of which is dated the 1st of October, 2025. The thrust of which is, in terms of prayer 2 thereof, seeking the recusal of my lady and your lordships presiding in this bench for the reasons that are alluded further in the supporting affidavit of the petitioner applicant. Respect, in deference to the upholding of the dignity of this, so that then we can get the issue: is this bench going to go forth, or my Lord, I don't want to argue my application, but if you allow me, the petitioner has laid the grounds to say that his faith in the administration of justice, in dispensation of justice, in this particular petition has withered completely, because his petition has been isolated when there are other similarly framed petitions raising similar issues. They may be worded differently, but the centerpiece and the linchpin of the consolidated petitions is the impeachment of the Honorable Rigathi Gachagua as Kenya's Deputy President, and the appointment now of the 10th respondent hearing, Honorable Abraham Kithure Kindiki. Now, he perceives that he's being discriminated against, and he's been kept aside, and therefore the danger that he and the prejudice he stands to face is threefold. So that then you see the necessity to give these precedents that he will have had this particular petition not heard together with the other one, yet the Supreme Court has held in decisions that I've cited in the body of the motion that where issues are raised of a similar nature, in saving judicial time, which is precious, and in enabling the courts to make a determined decision on all.
I don't think it is right for you to argue your application. What you have informed us that you have filed an application which is seeking the recusal on the bench.
Thank you.
I don't think it's in order for you to go ahead and argue it as if parties, because the effect of that application was probably engineered to derail the hearing which was going to take place.
My Lord, I beg not.
Yes,
thank you.
We came here for a non-application dated 8th of May 2025. But by the opening statement by Mr. Tinajui, he has introduced another application which is apparently engineered to deflect or to delay the hearing of this other application. You have stated it. I want a response from the respondents.
It's an application for recusal. An application for recusal, you know, has. We will need to take instructions to respond to it. My Lord, we had agreed with my colleagues in respect to the application that was supposed to come up for hearing today, and we were ready to proceed. But because application for recusal, in giving directions, the court gives us time to respond to that application. That would be all for my part.
For the first and third respondents, together with the 10th respondent, Mr. Mbaya. For the first, third, and 10th respondents, we also confirm that you have been served with the said application this afternoon by Mr. Harrison Kinanjui. It's an application for recusal. My Lord, my Lady, a peruse of the said application, the prayer sought, particularly prayer number 2, is more or less the same with the prayer number 3 in the early application, but considering
reiterate the sentiments by my colleagues. However, Mr. Counsel Mbaya has pointed out something very important, that the prayer sought in the current application, which has just been passed to us, a plain reading of the same reveals that it is... Yes, my Lord. My apologies. Prayer C in the application dated the 28th day of May 2025 is couched, and rather it is a veiled recusal application. In fact, when you read the body of the said application, it reveals grounds such as bias, which are the same grounds that are in the present application. My lords and my lady, we are concerned that the application as filed and served upon us today constitutes a facelift of the application dated 28th day of May 2025 and is indeed a dilatory tactic by the petitioner. My lord and my lady, we submit that we were ready to proceed with the highlighting of submissions with regard to the application dated the 28th day of May 2025. That will be all.
We were indeed ready to proceed with the application that was slated for hearing today. We had filed in response our grounds of objection, our submissions, and our list and bundle of authorities, all dated the 7th of July 2025. Regarding the application for recusal that Learned Counsel for the petitioner has referred to, we have not had sight of that application. We have not been served with the application, perhaps because it was short notice or maybe an oversight on the side of the Learned Counsel. We'll be requesting service of a said application. And my Lord, as rightly pointed out by Learned Counsel to the Attorney General, Mr. Emmanuel Bita, an application for recusal would automatically take precedence. We are ready to take direction.
On behalf of the 8th respondent, we similarly confirm we have not been served with the said application. Perhaps, my name is Obura. Perhaps counsel for the petitioner can serve us with the said application, and we'll take instructions on the response. I similarly echo the sentiments of my seniors that an application for recusal takes precedence, and therefore we are ready to take directions before you.
Email addresses. As I indicated earlier, had I gotten the WhatsApp messenger numbers from a lot of friends, I would have equally given them, but they were not present as at that time. And that is because of the quorum sheet not being available to us. So really, there is no mischief or bad faith on that. As an officer of the court under Section 56 of the Advocates Act, I owe a duty of responsibility to this honorable court and to my life friends to be faithful to that bona fides. Secondly, as indeed my lot of friends have acknowledged, this is a standalone recusal motion. The previous motion dated May 2025, what is being alluded to is separate and distinct because there was a legitimate expectation on the part of the petitioner applicant that the consolidated petitions would be together. So the canvassing of that particular plea would then be in light of the other counsels being given also to participate. And that's why it was worded the way it was worded at that time. However, subsequent to your order isolating this particular petition, the petitioner feels that that cannot adequately cover and canvass the issue at hand because it is the events subsequent to that that have provoked this application in the greater weight, in the greater measure. So it is not right to say that that plea was raised and this now has been raised as a quote-unquote dilatory tactic. So I wish to differ with my learned friend on that score.
Thank you.
Let me say lastly, my Lord, it is in deference to the right to be heard that a litigant files any application moving the court. So it is only just and fair that then this be ventilated. And because it was a standalone application, raising the plea in the application, then it ought to be canvassed. Thank you.
Honorable PJ, I believe this is a straightforward matter. We give directions in respect to that application. They file their responses and submissions, and then we proceed to fix the matter for ruling. There's no need of highlighting. This is a straightforward application. Thank you, PJ.
Address you on his opinion, with tremendous respect to his lordship, the Honorable Justice Murima. What I hear him say is that then there is nothing more but to give a ruling date on the motion dated 28th of May or it could be read that he's saying that then we can proceed on the motion dated 1st of October 2012.
What are you saying? What are you saying, Mr. Kinyanjui?
His Lordship's position, at least the petitioner needs to be clear about it, because what the petitioner effectively is asking for is the directions of the court on this particular issue, which London Council has agreed to. They need to have a look at the application, they need to respond to it, and they also, we also need to have these take precedence over the motion dated 28th of May 2025. That's a clarification that I need from His Lordship's remarks, because then I heard him say that what he's saying is that there's no hearing, we'll just proceed and give a ruling date for the 28th of May 2025 motion. Probably I misapprehended His Lordship's directions. Thank you.
Honorable PJ, if I may, Nyanjuri. You tend to hear simple, this is what I said. In view of the application dated 1st of October, it obviously takes precedence. Your colleagues have sought for time to respond to that application. My view is we give them time, they file their responses, you file submissions, they file submissions, we fix that application for recusal for ruling. We do not need to hear highlights on that application. The result of my proposal is that the application dated 28th of May will be held in abeyance pending the outcome of the recusal application. I don't know whether I'm clear now, Mr. Kinyanjui.
My Lord, you are then and I don't mean to be rude in any way, or in any way.
For recusal, of course, takes precedence over the application dated 28th of May 2025. Let that application dated 1st of October 2025 be served forthwith on all the respondents if that has not been done. Get the addresses for all the respondents and serve it. The recusal application shall be responded to within 14 days. Respondents get that clearly. Thereafter, parties shall file submissions within 14 days after the responses have been filed, beginning with the applicant. The applicants will have 14 days to file their submissions, and time shall be of the essence. After you file your submissions, the respondents also shall have 14 days to file their submissions. We will deliver a ruling on this application for recusal on 30th of November 2025.
With your permission, if you could grant me leave to file a supplementary affidavit.
Yes, yes.
If need be.
Yeah, if need be, you can file any rejoinder. But those timelines are of essence. And we have deliberately made it like that because we are dealing with very urgent matters. So that we will deliver you a ruling on 30th of November 2025 using the pleadings which are on record.
Just confirm. What day of the week is the 30th? Which is that?
On 2nd of December.
My Lord, so they are also furnished with the order of time of the essence. In fact, I'll highlight.
Yes, yes, yes.
So that no one says.
What do you prefer?
Then we can take directions as the case may be. Just like now. It's
Yes, yes, yes. Yeah, come.
And the failure of guidance, then
Come at 2:30.